Good day, guardian ad litem volunteers. My name is Brian Ciula, and I am a Child Advocacy Manager with the First Circuit Guardian Ad Litem program. We would like to thank you for joining our program. We look forward to working with you after you've completed your training. This presentation is just one of several that you will review in our efforts to make you a competent and confident child advocate. We will start our journey on the road to child advocacy. Good luck in your assignment. Good day, volunteers. Welcome to the Guardian Ad Litem program. We'd like to thank you for being here today and joining our program. You've obviously made a commitment to children and to assisting children who have been abused, abandoned, or neglected. This presentation, along with several others, which you will review, will give you, we hope, the confidence and competence to be an excellent child advocate for those children you represent. So let's begin the journey on our road to child advocacy. Today we're going to cover several different topics. We're going to talk about the mission of the Guardian Ad Litem program. We're going to talk about what it is to advocate for a child, what best interest means, the volunteer's role in the program, the concept of professionalism, and of course, confidentiality. Let's start out with the mission of the Guardian Ad Litem program. These are 10 words that you should never forget. Advocating for the child's best interest is our only interest. Next, we'll talk about advocating and what that means, as well as what best interest means in the concept of a dependency case. Dictionary.com says that an advocate is a person who pleads the cause of another in a court of law. And that is exactly what you, as a Guardian Ad Litem volunteer, will be doing. You will be pleading the case of a child who is either too young to state to the court what they would prefer, or a child who is afraid, or just a child who doesn't understand the system in dependency court. In the simplest terms, you are the voice for the child. Now, what is best interest? Best interest can take on many forms. You may be advocating for the children to be reunified with their parents. You might be advocating for a child who has mental health issues and needs therapy. You could be advocating for a child who needs to be in daycare and needs to socialize with other children. Another type of advocacy or best interest is educational advocacy. And you may be advocating for a particular educational program for that child. On the other end of that spectrum is a time when you may be advocating for termination of the parent's rights. Now, in many cases, this never happens, but it is something that will be discussed further, especially during the legal briefing, which you will receive later on. The bottom line is that there are many types of best interest and many ways to advocate for a child in dependency court. As your case moves along, you will realize that there are other types of advocacy and other areas where the child's best interest must be represented by the Guardian Ad Litem program. Next, we'll talk about your role in a dependency case. You are the eyes and ears of the Guardian Ad Litem program and the court. The judge in a dependency case looks upon you as the volunteer, as a person who will give a totally unbiased view of what is going on with the child in your case. You will not be swayed by the parents' views, by the custodian's views, nor anyone else's view. You will present the unbiased opinion of our program. Another role you will take on is becoming a friend to the child. That is a fine line that you must walk between being a friend and being an advocate. Sometimes you need to advocate for things that the child or children in the case do not actually want. However, you know that that is in their best interest. You will also be an advocate for the child. Again, that is advocating for what the child wants or what is in his or her best interest and presenting that information to the court. You will be the voice of the child. Again, that is a child who may be too young to speak for themselves. It may be a child who is afraid to speak, or it may be a child who just doesn't understand the dependency court system. And they will depend on you to speak for them. Next, you will be the voice of best interest. As we discussed earlier, best interest takes many forms. But you, as the guardian volunteer, will always look out for the child's best interest within the confines of the dependency case. Finally, you as a volunteer are a professional observer. You, through your visits with the child, whether they be at home with the parents, at the custodian's home, in school, in daycare, or during visits with their parents, you will observe and you will report back to the Guardian Ad Litem program what is going on with that child and what your recommendations are. The next thing I'd like to speak about is professionalism. We expect our volunteers to be professionals in all that they do during the life of the dependency case. BusinessDictionary.com defines professionalism as meticulous adherence to undeviating courtesy, honesty, and responsibility in one's dealings with customers and associates. One of the key words in this definition is honesty. Many times, a Guardian Ad Litem volunteer will have to recommend things that do not agree with the parent's position in a case, or may not even agree with the position the child wants in that case. But we need you as the volunteer and the eyes and ears of our program and the court to be completely honest about what is going on and what is necessary to assist that child. The qualities of a professional, and these are just a few, are trustworthiness, competence, and respect. Respect can go a long way towards helping a child. You must gain the respect of the child, and you must gain the respect of the parents and the other parties in a case. I'd like to tell you about a few of the professionals that we work with day to day as we advocate for children in the dependency court system. We work with judges, magistrates, and attorneys, of course, normally in the court during court hearings. We work with child protective investigators who work with the Department of Children and Families at the guardian attorney present. However, we want to make sure that you understand that this is a prohibition unless the Guardian Ad Litem attorney is present. One of the places that we are on display as far as professionalism goes is in the courtroom. And we ask that our volunteers dress conservatively and appropriately for court. We would remind you that all parties are addressed by their title: Judge or Your Honor, Magistrate, Mr., Mrs., or Ms., and their last name. You may be called on to speak regarding the child in your case, and you may have the possibility of addressing the parent in a case. And please always refer to them by Mr. or Ms. or Mrs. and their last name. Do not refer to them by their first name. If you have information that you wish to be brought up to the judge during court, you must first coordinate that information with your child advocacy manager as well as the guardian ad litem attorney before the hearing. They will decide what needs to be brought up to the judge and when it is appropriate to insert that information. While you're in court during your hearing, please never blurt out information. The guardian ad litem attorney will determine what should be said and will have you recognized by the court prior to you speaking. We would also remind you that in court we sometimes have parents who are incarcerated. And there is a certain protocol in dealing with incarcerated parents. Please never speak to the parents without the approval of court or prisoner security. And please do not give anything to the parents or touch them in any way. Always get the approval of court security prior to dealing with incarcerated parents. Now, I have a recipe for a professional guardian ad litem volunteer, and this is done in fun, but it covers a lot of important points. We take one dedicated individual, we mix with a heaping helping of concern for children. We combine that with observable, quantifiable facts. We add a dash of confidentiality, stir frequently with your child advocacy manager, and voila, we have one professional gal volunteer. I'd like to talk briefly about observable and quantifiable facts. During your assignment on a dependency case, we always expect you to deal in facts, not personal opinions, not others' opinions, but things that can be verified and quantified. The other issue in working a case is confidentiality, and we're going to talk specifically about that. Dictionary.com says that confidentiality means limited to persons authorized to use the information and the documents, etc. As a guardian ad litem volunteer, you are given legal authority to obtain a large amount of information regarding the children and sometimes the entire family. And we must be careful that we deal with this appropriately and that we do not inadvertently or directly provide confidential information to parties who are not authorized to have that information. When you take a case, you will get an order of appointment signed by a judge which appointed our program to this case. You will then sign a notice of acceptance, which means you accepted that case as the guardian ad litem. These two documents give you the legal authority to obtain the information you need to advocate for the child or children in your case. Again, all case information is treated as confidential. Also, any information you obtain during the life of your case must be turned over directly to the child advocacy manager, who will then make sure that the attorney assigned to the case gets that same information. Now, who can you share information with when you're assigned to a dependency case? Well, generally the rule is that you can share it with legal parties to the case. And you might ask, well, who are the legal parties to the case? Of course, the judge or the magistrate is one party to the case. The Department of Children and Families attorney and the caseworker and the child protective investigator are another set of legal parties. Also, the mother and her attorney and the father and his attorney are legal parties. And finally, the guardian ad litem volunteer, the child advocacy manager, and the guardian attorney are legal parties to a dependency case. Now you might say, as an example, let's say that grandma and grandpa had custody of the child, and the child was then returned to the parents' custody. Now you've built a relationship with grandma and grandpa, and from time to time they call you asking about the case and the children and how things are going. While you can provide information regarding how the children are doing, you can't necessarily discuss what the parents are doing on their case plan or information that would normally only be privy to the parents and their attorneys and the court. You also have probably visited schools for the school-aged children, and you've developed a relationship with the teacher who teaches that child. The teacher can provide you with information. However, you are not authorized to provide your opinion on the case or information you have gathered from other sources back to the teacher. Now, there's a careful line that we must walk when observing confidentiality in a case. The concept of obtaining information versus providing information is very important. The guardian ad litem volunteer has, as I have said, legal authority to obtain lots of information regarding the children, from teachers, doctors, therapists, providers of social services, the child protective investigator, and the family services counselor. However, you are not authorized to then provide information you have obtained to other people in the case. Only with the approval of the child advocacy manager and the guardian ad litem attorney would you be allowed to provide information to other people. Examples would be, as I have discussed, a teacher who asks you about the goings-on in the family. Granted, the teacher knows a lot about what goes on in that family. However, you should not be providing your observations to the teacher. One example of a record that you may obtain that is sometimes very critical in physical and sexual abuse cases is from the child protection team. They are charged with interviewing and conducting physical examinations of children who have been abused when it involves physical or sexual abuse. We often obtain their reports in those types of cases, and you as a volunteer are going to do that eventually. Their record is not releasable to anyone other than the agency that requested it. In other words, we have the legal authority to obtain that information, but we do not have the legal authority to then provide that information to anyone else. Any other agency who needs that information must go directly themselves to the child protection team with the document that gives them legal authority to have that information. As I've spoken earlier of grandparents, relatives will sometimes find out who the guardian ad litem volunteer is on a case and somehow be calling our program asking for information regarding the children. You are limited to basically saying how the children are doing, and that's really all you can say. You do not provide information regarding the parents, what they're doing on their case plan, or what the situation is in the parent's home. One of the ways that we gather information is through the order that appointed us, the OAP, the Order of Appointment. And that gives you legal authority to obtain information regarding the children. Now, some of our newer orders also allow you to gather information regarding the parents. However, our older orders do not allow any information to be obtained regarding the parents. If you need specific information on a parent or as to what they've done on a case plan with a provider agency, the best way to go is to have them sign a specific release of information, and that will protect you and protect the Guardian Ad Litem program from getting into trouble. If you ever have any question about what you're allowed to release or who you can provide records to, always call your child advocacy manager first, and we will get the clearance for you to do what you need to do. Today we've talked about a number of things. We've talked about the mission of the Guardian Ad Litem program. Advocating for the best interest is our only interest. We've talked about what advocacy is and how you advocate for children. We've spoken about best interest and what you may determine is in the child's best interest and what we need to provide to the court. We've talked about your role in a case. The most important role you play is to be the eyes and ears of the Guardian Ad Litem program and the court regarding those children you are assigned to. We ask that you as a guardian volunteer always be professional, whether it's professional in court or professional in dealing with other agencies, the family, the children. We ask that you always be professional and respectful of the family's needs. We also talked about confidentiality. It is inherent that we protect the information that we gather regarding a dependency case. Our program is bound by laws in the state of Florida, and we ask that you follow those laws and follow our guidance regarding confidentiality. This has been the first presentation in a series of presentations that you will review, which we hope will make you a competent and professional advocate for the Guardian Ad Litem program. We hope you've enjoyed this presentation, and we look forward to working with you in this program. Thank you, and have a great day.